In this session, we're going to continue our discussion on contracts. This is part 2 of the discussion. If you've not watched the first video, you need to go back and watch it, as this video will build upon the principles that we talked about in the first video. So we've talked about what it takes to make a contract now. In our example of the painter and the homeowner, we have the easy example that they go through of there's a meeting of the minds. They both understand that there's an offer of painting the house in exchange for $2,000. There's an acceptance of it. So there's a meeting of the minds. There's consideration through service of painting and money payment for those services. Um, there's capacity in both of them. They're both of age. There's no mental incapacity there. And then um, contracting to paint a home is perfectly legal. It's not against public policy. So we have a valid and binding contract. Well, now can the parties decide to amend the contract? Now the painter has decided, the homeowner has now decided that instead of just painting the inside, he now wants to paint the outside of his home too. And so he's offered an additional $2,000 to paint the outside as well. Well, the parties may agree to modify the contract. So their contract of painting the inside for $2,000 may be modified to paint the inside and the outside for $4,000. So to be valid, the modification again has to have a meeting of the minds. There's got to be an agreement to the modification, the terms. The modification, just like with creating the contract, it can be orally, it could be written, it could also be implied by conduct. So if the modification could show up in that the offer or the homeowner tells them, hey, I want to paint this, I'll pay you an extra $2,000 to paint the outside. And then the homeowner goes to work one day, they arrive home, and when they come home at lunch or after the day, they notice that the painter's outside with his workers and they're painting the outside of the house. Well, obviously, the conduct of starting to paint the outside of the house would be evidence of the contract modification to include painting the outside of the house for an extra $2,000. So we've talked about these requirements and what it takes to create a valid binding contract. There are circumstances, however, where a court may find that despite the appearance of all four elements being there to create a valid and binding contract, there was no true meeting of the minds. So it may be apparent that there was an agreement based on an individual analysis of the four requirements, but there are certain circumstances that are present that indicate that the parties have not truly agreed to the terms, to the essential terms, and as a result, there is no contract. So we've got 3 instances here in which there's no true meeting of the minds. One is fraud, next is duress, and last, mistake of fact. We'll now look at each of those briefly. So fraud. A contract that's procured under circumstances of fraud is voidable. You have fraud in fact, which is where the contract is made based on an untrue statement about a material fact. In other words, it's a misrepresentation. And it's a misrepresentation to the extent that the person does not understand the essential terms of the contract. The good example that's given in the book is the person signs a deed of trust to transfer property when the person is told that it's an employment agreement. So clearly, there is a fraud that's being perpetuated upon the person who's signing the deed of trust. He thinks he's signing an employment agreement, believes he's going to work for the person or company, but instead he transferred his property. Obviously, under those circumstances, the contract should be deemed procured under circumstances of fraud and would be void. Fraud in the inducement is similar, but it's where a party makes a false statement to entice the person to enter into the agreement. Again, the book gave a really good example where a jeweler calls a person or tells a person that the ring is a diamond ring when in fact it's a zirconium. In that instance, the person has the option to cancel the contract. But for them to have that option to cancel the contract under either theory of fraud, the misrepresentation must be material and it must be relied upon by the person in deciding to make the contract. So in the jeweler instance here, since it's right here, let's take it. The misrepresentation is clearly material, because if you're buying a diamond ring, why are you buying it? You're buying it because of the diamond. And the fact that it's not a diamond but a zirconium is a material term. And then obviously the person is relying upon the representation that it is a diamond when they're deciding to make the purchase agreement. So in fraud, though, you've got to remember that the concept of puffing. We'll talk about that more in sales, but puffing is where you are trying to bolster or sell something. It goes back to the like an example of if you're selling a car salesman may tell you this is the fastest car on the lot. This is, one of the nicest cars on the road. That's mere puffery. They're trying to sell you on some opinion about the car, but it's not any real guarantee. So you got to distinguish fraudulent misrepresentations from puffing. So you have promissory fraud as well. Promissory fraud can occur where a party promises that they're going to perform some act knowing that they have no intention of completing the act. So if our example of the home owner and the painter, if the homeowner promises to pay $2,000 to the painter once he finishes painting the house, and the homeowner knows that they're not going to pay that $2,000 once the home is done being painted, then the homeowner is committing promissory fraud. So in that instance, the contract is not invalidated, but rather the painter would have a claim for breach of contract after the homeowner fails to pay the $2,000. So duress, this is the next example or next form in which you may not have a true meeting of the minds. So duress is when a party is forced to execute the contract. It's usually done out of fear through threats or physical threat. It may be extortion or blackmail, but this is where there's no true meeting of the minds because you're only agreeing to the contract because of fear or threat. So in this instance, the contract is voidable, and the threat needs to be wrongful or illegal. So the third type is a mistake of fact. If the mistake of fact happens, the contract's voidable. So if there's a mistake of fact, then there's no true meeting of the minds. Generally, a unilateral mistake by one party does not make the contract voidable. The exception to that is when the mistaken party made an unintentional mistake in preparing the offer, such that the offer was really too good to be true. So if the offer was just at like a ridiculously low price of, like let's go back to that example of that we talked about earlier of I'll sell my car for $30. If that was the offer that was made, the unintentional mistake may be that they had a typographical error, and instead of it being $30,000 like it was supposed to be, it came as $30. In that scenario, the mistaken party's unintentional mistake when they prepared the offer would be an exception to this, and the contract would be voidable. So to determine if there's a mistake of facts, you consider three factors. The substantiality of the mistake. So when the mistake has a material effect on the party, then it's more likely that the contract will be void. So that means it's a substantial mistake. You got to look at whether the risks were allocated. If a party agrees to a risk, then he's bound by the consequences if the risk occurs. But on the other hand, if there's no agreement, the court will determine which party should be allocated the risk, which party should bear it. Timing, in that sense, you always look for prompt notice of the alleged mistake. Ambiguity. The book lists the ambiguity as another instance in which there may not be a true meeting of the minds. I don't agree with that characterization because an ambiguity does not invalidate the contract. Rather, an ambiguity just means that you've got to do some thinking about how a term or provision should be interpreted or construed. What is the true meaning of the clause, the provision, the word, whatever term or clause or phrase is deemed to be ambiguous. So the examples we've been talking about, mistake of fact, arrest, fraud, all of those make the contract voidable, can invalidate the contract. Maybe in limited jurisdictions, an ambiguity would invalidate the contract, but it doesn't in a majority of them. And that's why I don't list it as a true instance or a true example of where there may not be a true meeting of the minds. I understand their perspective on it, but I think it's different in the sense that it's not a lack of genuineness in the meeting of the minds such that the contract is deemed invalidated. Rather, it just means that the courts will have to look at parties' intentions outside of the written document to determine what the term is meant to mean. So just like I'm saying, an ambiguity just means that a court must interpret the contractual provision or terms to determine what the party's obligations are. So an ambiguity, when does that exist? What is it? Well, an ambiguity is when the term is subject to two or more reasonable interpretations. So a clause could reasonably mean different things. And when the clause or term could reasonably mean different things, then you have ambiguity. It's important to note, though, that ambiguity doesn't exist just because the two parties each proffer a different interpretation of that term or clause. So if the painter and the homeowner each interpret the provision of their contract differently, that doesn't mean that the provision is ambiguous, because just their differences, because that's what always happens, is the parties always disagree over the critical term of their dispute. That doesn't mean that that term, though, is ambiguous. There are a lot of times where courts look at a term and decide, well, you both interpret it differently, but it really doesn't mean two different reasonable interpretations. There's only one reasonable interpretation. And so a lot of times, just because there's a dispute and two people have different views in the contract doesn't mean that an ambiguity exists. Generally, in contract interpretation, courts are confined to the four corners of the contract. By that, I mean that the court, when they're trying to determine what the obligations and duties of each party are under the contract, they only look at what's in the contract. They don't look at what the parties talked about or any of their written communications about offers and counteroffers and all of that. Rather, they're confined to the four corners of the agreement. That is an important thing, in that it's a good point to think of if you're ever in the situation of drafting contracts, is you need to try to be specific and clear in your agreements, because you don't want there to be ambiguity in it. If you are worried about what does this mean, or does this convey what we are agreeing upon, it needs to be in the written document, because the parties' unexpressed intents are not going to be permitted in a contract. I've got breach of contract case that's going on right now. It's over a home construction loan, and the terms of the agreement, it's talking about when advances would be made under the construction contract. The language is that a dispersal will be made, quote, upon borrower request and lender approval, end quote. And so the the bank made a payment because the construction contract set forth completion stages. So if a certain amount of work was done, then they were to make a payment. And the builder reached one of those stages, and he came in and requested a payment. The bank went, they confirmed that the work that was required for that completion stage had been completed, and they agreed, and they made a disbursement. Before they went to before the builder came to the home or to the bank to get money for the home, he told the buyer that he was going to go to the bank and request the second payment, and she didn't have any objection to it. But now she sued our client, and she contends that the language per borrower request and lender approval required that the bank have her approval or permission before they made a payment. And quite frankly, her argument is when the bank talked, that's what they talked about doing is them getting her permission. And there's some favorable deposition testimony to that effect. But when we got into the case, the judge has ruled that the term per borrower request doesn't mean borrower approval. The only person that has to approve it is the lender. And so that's an example of an instance in which there's no ambiguity, and the court is confined to the four corners of the document of the loan agreement. But the borrower is arguing that they should look beyond that and look at what the parties intended to express based on what she was told and what their discussions were. But you don't get to that because you're confined to the four corners of the contract because there was no ambiguity in that contract. Borrower request is clear. It means that the borrower, or in our instance, the borrower's agent, requests a payment, and then the lender approve the payment. And that's what happened in our instance, and no breach of contract by our bank. So the rules of construction is that ambiguous language is construed against the party who drafted it. So in our example of the bank drafted the promissory note. So if that term was found to be ambiguous, then it would be construed against the bank since they were the one who drafted it. Meaning that they would have probably gone with the interpretation of the borrower, and that the term of the note required that the bank get her permission before they made a dispersal. So we talked about if there is a ambiguous term or something that the courts may look to the statements of the parties, what they said, what they exchanged in writing. Well, that's parole evidence. Parole evidence refers to all those prior communications or statements that they have when they were forming the contracts. The emails, the text messages, what they'll say was said, all of that would be parole evidence. And if the contract is ambiguous, then the parole evidence could be used by the court, considered in helping them interpret the ambiguous term. It helps you to find out what were the parties' intentions, even because the contract didn't express those intentions clearly. But on the other hand, if the contract is unambiguous, that means the term is not subject to more than one reasonable interpretation, then parole evidence is inadmissible because the interpretation is confined to the four corners of the document. So if the term is not ambiguous, then the terms of the contract controls, and you do not consider any of the prior contemporaneous statements, emails, text messages that were done during the process of executing the contract. Um, Unconscionability. This is a doctrine that comes up when we're talking about terms. Um, it's contractual terms that are too strict or too harsh or too unfair, and they're so harsh or unfair that it, quote, shocks the court's conscience, close quote. That means it's just a very appalling term to the contract. There's a good quote in the book that from a case. It's no honest man in his senses and not under delusion would make on one hand, and as no honest and fair man would accept on the other. So it's an agreement that an honest, an objective, reasonable person, they would not make the offer, and then the other person, reasonable, objective standard, would not accept that offer. That's a good way of defining an unconscionable term. A fair, reasonable person wouldn't make that offer, nor would a fair, reasonable person accept that offer. So unconscionability is often rare in the business setting, especially because most of the time the people that are negotiating things are sophisticated people. Businesses, you have executives that are uh, negotiating these contracts. They're sophisticated people, and there's sophisticated people on both sides of the contract. Business working with another business, and so it's unlikely that courts will find a term to be unconscionable. So unconscionability usually comes up the most in these contracts that are not at arm's length. We talked about the usury statutes, for example. Those are very one-sided. You have the big company that has created this form. It's their standard stuff. It's definitely boilerplate language that's slanted in their favor. By boilerplate, we mean it's standard, pre-written, pre-typed terms that are favorable to the party that's offering it, and it's contracts that will contain terms that you or I would not think to include, and that are highly against our best interest. So, but in the instance of these contracts with these loan companies and people, you could have some provisions that would maybe shock the conscience of the court. An example could be the interest rate. You could get one of these where they charge, like we said, they may not know the usury statute that's in effect because they've got a bunch of these contracts for a bunch of different places, or the usury interest rate may change. And they haven't realized it yet. But you could have one that was so high that it would shock the conscience of the court. So when a term is deemed unconscionable, then the court will refuse to enforce that term. Just like the example of the interest rate, if they deem that to be an unconscionable term, then they're going to impose a different, lower interest rate than the one that's deemed unconscionable. Now, the only time that the contract is usually deemed unenforceable or invalid is when the term is an essential term. So if it's an essential term, then the court either will rewrite the term or they'll void the contract. But if it's a material term, it's more likely that they'll void the contract than they are to rewrite the term. Reason being is with a essential material term, then the less likely there is to be a true meeting of the minds such that you can rewrite and find an acceptable alternative term. The implied covenant of good faith and fair dealing. Every contract contains this implied covenant of good faith and fair dealing. This means that every party is obligated to act in such a way that they do not hurt or harm the other party of the benefits of the agreement. So the painter, for example, with painting the home, he has an implied covenant of good faith and fair dealing. So if you take the example of going and buying paint, the homeowner may have paid money for a certain grade of paint, and the painter, that may be a high, expensive cost paint, and the painter may decide to go and get the cheapest form of paint that he can, and it may save him $30 a gallon. But he's being paid the extra money to cover that $30 extra per gallon. And so by him getting the cheap paint and using it to paint the home, he is, in my opinion, violating this implied covenant of good faith and fair dealing, because the party is being deprived of the benefit of the agreement being that he gets this good top of the line paint. So that's an example of where the implied covenant of good faith and fair dealing would be violated. So a couple of good points to live by to help you decide if you're violating this implied covenant of good faith and fair dealing is, as a company, would it embarrass you or the company if what you were doing was made public? Second, would you act the way you are if you were dealing with either a close friend or a family member? For the painter, they would probably tend to not buy the cheap paint and pocket $30 for each gallon that he bought if he was painting his mom's house. If he was painting his best friend's house, he would probably buy the good paint and not do what he's done to the homeowner in our scenario. Statute of frauds. We've talked about earlier how contracts can be in writing or they can be oral. Well, there are certain contracts that have to be in writing. At least some portion of the contract has to be in writing. And this is known as the statute of frauds. And the statute of frauds is a concept that requires that certain contracts be in writing. The statute of frauds is an affirmative defense. That means that it's a defense that has to be raised in order to invalidate a contract. So a court's not automatically going to look at a statute of frauds. It's not an element to go through and say to be we talked about the 4 requirements to be a binding contract. There's not a 5th one that's added in there of, does the statute of frauds apply, and if so, is the agreement in writing? That doesn't apply. If the contract is under statute of frauds has to be in writing, the contract will still be enforced if no party raises the statute of frauds as an affirmative defense. So if you don't object to the contract as not being in writing, then you are essentially waiving that right, and the contract will still be enforced against you, even though it may be under a statute of frauds defense an invalid contract. So here are the agreements that usually must be in writing. When you have a sell or lease of land, when you're selling land or you're leasing land, you've got to have that agreement in writing. If it's an agreement that can't be performed in 1 year, this is the one that becomes the hardest to know, because sometimes the agreement may be something that is believed that can be performed in 1 year, but as it later proves, it actually took longer than a year to perform. So those are probably of these ones, this is the one that's the hardest to know when you need to get it in writing as opposed to just an oral agreement. Prenuptial agreements, these are the agreements that you sign before marriage. Then lastly, an agreement to pay the debts of a third party. So if you're going to pay the debt of someone else, it has to be in writing. So when we talk about a contract, I said it just has to have some form of writing. It doesn't have to be a formal, drafted by a lawyer contract. The writing the writing requirement may be satisfied by just the mere communications that go between. It may be some sort of offer that's written in an email, and there may be a correspondence back accepting that. That could be sufficient to establish the statute of frauds and get you past that defense. The only requirement between the writings is that they require to have the essential terms. So you've got to have the subject matter, the price, the duration of the contract, form of payment, things like that that are material terms. You don't necessarily have to have written down um, that we agree to arbitration or we agree to a choice of law clause of Tennessee law. What you need to have is the essential terms, and that's what the statute of frauds requires to be in writing.